A key witness in the Mar-a-Lago documents case in late June changed his testimony and further implicated Donald Trump and Walt Nauta, and the third individual who was indicted in a superseding indictment, whose last name is De Oliveira. What's going on? So, at the last hearing in front of Judge Eileen Cannon, taking a talking point directly from one of Trump's lawyers, or one of his former lawyers that she had seen on Fox News the night before, and I'm not kidding about that. She watched one of Trump's former attorneys on Fox News and took a talking point from him and brought it into this proceeding. That, well, why was there a grand jury in Miami and a grand jury in D.C. that were investigating this same set of circumstances? Which isn't a thing. That's not a thing. So today, what is today? Today's Tuesday, the 22nd. Jack Smith filed this pleading, providing her with some additional information about why that is, what happened. So part of the investigation for the Mar-a-Lago case took place in Washington, D.C. and utilized a grand jury in Washington, D.C., I think largely because that's where Donald Trump stole all of these documents. He stole them in Washington, D.C., and then took them to Florida. And so Jack Smith, and again, this is a 12-page document. There's about 9 pages of it that actually matter. It's a very easy read. It is called Reply in Further Support of Government's Motion for a Garcia Hearing. Garcia references a case, and I'll get to that in just a moment. And so, but it basically lays out the timeline that following the indictment in this case, which landed on June 8th, Jack Smith continued to investigate. Specifically, he continued to investigate false statements that were made by the now indicted De Oliveira and Trump employee number 4, the guy who changed his testimony. And that guy's name is Yuscil Tavares. He's an IT guy. And this all relates to this little conspiracy that they had to, the 4 of them, Trump, Nauta, De Oliveira, and Tavares, to delete security footage, security camera footage shot within Mar-a-Lago after the government had subpoenaed that footage. And so it turns out that Mr. Tavares' attorney, the guy whose last name was Woodward, was also representing De Oliveira. He was representing both of those men in this same case. That presents a conflict of interest. How does that present a conflict of interest? Well, say one of them takes a stand and testifies against the other. Well, then Woodward has to vigorously cross-examine his own client for the benefit of his other client in the same case, thereby damaging this client's case, which you can't do because you're his lawyer. So that is the conflict of interest here. But the government, so De Oliveira and employee number 4, Tavares, who we're talking about here, had both testified to the grand jury in Washington, D.C. So their testimony took place in Washington, D.C., in that jurisdiction. In continuing the investigation after the first indictment had been issued, the government discovered, oh, this testimony is false. Jack Smith specifically addresses the testimony of Tavares in this pleading that he filed today. So they continued to investigate that in Washington, D.C., and because they had indication that Tavares' testimony was false, Jack Smith sent Tavares, through his attorney, Mr. Woodward, a target letter saying, you're a target, we think you committed perjury. And then Jack Smith also notified attorney Woodward of this potential conflict. And he was like, it's not a conflict, I don't care. And so then, like 2-3 weeks later, on June 27th, Tavares filed with the chief judge in the D.C. District Court basically, I want a motion for a conflicts hearing, basically wanting the judge to weigh in on whether or not this was a conflict. At that hearing, I think it was at that hearing, Tavares notified the court that he did not want Woodward representing him anymore. He wanted to go with a federal public defender, and the judge was like, absolutely. Immediately after receiving new counsel, Trump employee number 4, Tavares, retracted his prior false testimony and provided information that implicated Nauta, De Oliveira, and Trump in efforts to delete security camera footage as set forth in the superseding indictment. And the superseding indictment came a few weeks after that. Trump employee number 4 will very likely face cross-examination about his prior inconsistent statements in his grand jury testimony, which occurred while Mr. Woodward represented him, and at trial, presumably he will be cross-examined by Mr. Woodward. Let's see. Okay, so then something not super specific to this. I'm going to teach you guys something that we learned in law school about how to analyze this kind of stuff. We learned what's called IRAC, I-R-A-C, Issue, Rule, Application, Conclusion. So in these types of pleadings, you get these headings. The heading is going to be the issue. Continuing to investigate Trump employee number 4's perjury before the grand jury in the District of Columbia was entirely proper. And then you get rules. You always get a paragraph of either case cites or cites to statutes. So issue, rule, and then you get down to the discussion section, which is the application of the rule to the issue. And so they go through that, and it's kind of boring and not super important. So I'm not going to read all of that. But they just say that it was entirely proper for them to keep investigating in D.C. Because that's where those false statements had been made by these two witnesses. And you generally have to prosecute a crime in the jurisdiction where that crime took place. They didn't make their false statements in Miami. They made them in Washington, D.C. We talked about that already. Then, yeah, but this Woodward guy sounds like a slimy guy, man. And so it's interesting because the party who filed a pleading saying, oh, they can't do this, they can't investigate a crime up there and indict down here, the person who filed that pleading is defendant Walt Nauta. So who wrote that pleading? His attorney, Woodward. His attorney, Woodward, filed a pleading in Miami saying that the Miami court should preclude Tavares from testifying altogether, his former client, who's now going to testify against his current client, Nauta, because the government played shenanigans with these two grand juries when they didn't at all. But it's going to be interesting to see how Judge Eileen Cannon rules on this. If she rules in their favor, then my prediction is that's that for her. She's done. Jack Smith will immediately take that up to the 11th Circuit and get her ass bounced off this case. So Nauta contends that Tavares, employee number 4, should be precluded from testifying at trial at all, even though, if you remember from the video that I did a week or two ago about relevance under the federal rules of evidence, his testimony is clearly relevant because it makes true more likely than not an event that is being alleged, meaning that he's providing corroborating evidence for a fact that the government has put forth in its indictment. His testimony supports that, and that fact goes directly to the heart of the indictment, the obstruction, and his testimony supports that evidence that goes directly to the heart of the indictment itself. And so they conclude, issue, rule, application, conclusion. They conclude by saying the grand jury proceedings in D.C. were entirely proper. The court should hold a Garcia hearing, just to flesh it out some more, with Mr. Woodward's other clients present and independent counsel available to provide them with advice should they so desire it. Jack Smith's trying to yank this guy's other clients away from him, which is highly amusing to me because they probably don't know about this kind of conflict that's going on. and they're getting screwed over by this dude. He's being paid by Trump.